Last time we looked at where the numbers about Gaza come from and who produced them. This time there is a single question, and it is narrower. Does what has happened in Gaza meet the legal definition of genocide? Not whether the war has been devastating. It has. Not whether civilians have died in enormous numbers. They have. Not whether the humanitarian situation has been catastrophic. It has been, and famine was formally confirmed by the international body that makes that determination. The question is narrower than all of that, and deliberately so. Genocide is not the name for the worst thing that can happen in a war. It is a specific crime with a specific test, and that test is the highest bar in international criminal law. Higher than war crimes. Higher than crimes against humanity. The argument of this video is that the evidence available does not clear that bar, and that this remains true even when you take the strongest case against it seriously. So we will take that case seriously. We will put the strongest arguments on the other side directly on screen, including the ones that are rarely mentioned in videos that reach this conclusion, and then show precisely where they fall short of what the law actually requires. The 1948 Convention defines genocide in two parts, and almost every public argument collapses them into one. The first part is the physical act, killing members of a group, causing serious bodily or mental harm, deliberately inflicting conditions of life calculated to bring about physical destruction. Those are the acts. The second part is the mental element, and in law it has a name, Dolus Specialis, special intent. The act must be committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. Those last two words carry more weight than anything else in the sentence. As such, meaning the group must be targeted because of what it is, not because of where it is, or who is fighting from within it, or what a war is being fought over. This is a higher standard than any other crime in international law. Crimes against humanity require a widespread or systematic attack on civilians. War crimes require serious violations of the laws of war. Both are grave. Neither requires you to prove what was in someone's mind. Genocide does. And that is the entire difficulty, because intent is the one thing you cannot photograph, count, or measure from a satellite. So if intent cannot be observed directly, how has any court ever proved it? The answer is the most important sentence in this video, and it comes from the International Court of Justice itself, in the 2007 Bosnia and Herzegovina versus Serbia judgment, where intent is inferred from a pattern of conduct rather than shown by a document. That inference must be the only reasonable inference available from the evidence. Not the most likely, not the most compelling, the only one. If the same pattern of conduct can also be reasonably explained by something other than an intent to destroy the group as such, then as a matter of law, genocidal intent has not been established. This is not a technicality invented for this conflict. It is the standard the court applied to Srebrenica, where 8,000 men and boys were separated and executed. The court found genocide for that specific massacre and declined to find it for the wider Bosnian War, because for the wider war the pattern admitted other explanations. Same conflict, same court, genocide in one part, not established in another. That is how demanding this test is. The clearest way to see what is missing is to look at cases where the intent was proven. In Rwanda, the genocide was preceded and accompanied by a state radio station broadcasting instructions to kill, naming targets by name, and calling the victims cockroaches. Lists of Tutsi were prepared in advance. Roadblocks checked identity cards, and the identity card itself recorded ethnicity. The purpose was announced on air, continuously, while it happened. At Srebrenica, Bosnian Serb forces separated men and boys from women and children, transported them systematically to execution sites, killed them over several days, and then spent months moving the bodies between mass graves to conceal what had been done. The separation by sex and age is what proved the intent. There is no military reason to sort a population that way. In the Holocaust, there was a bureaucracy, transport schedules, budget allocations, purpose-built facilities, and a documented conference to coordinate it. Each of these left the same signature. Not simply mass death, but a system whose organizing purpose was the destruction of a group, visible in how the killing was structured. That signature is what a court looks for, and it is what is absent in Gaza. Before the affirmative case, deal with the thing doing most of the persuading in this argument on both sides. The imagery. Satellite photographs of Gaza are genuinely shocking, and the scale is not in dispute. The United Nations Satellite Service assessed in October 2025 that around 81% of all structures in the Strip were damaged. More than 123,000 destroyed outright. Over 300,000 housing units affected. That is not a few blocks. That is most of a territory, and anyone arguing otherwise is arguing against the United Nations' own satellite data. Two things follow from it, and only one of them is about intent. First, the geography, because the Gaza Strip is not a city. It is a chain of dense population centers: Gaza City, Jabalia, Deir al-Balah, Khan Yunis, and Rafah, and inside them sit 8 registered refugee camps established after 1948, which stopped being tents generations ago and are now permanent urban neighborhoods. Jabalia is the largest, 119,000 registered refugees in 1.4 square kilometers. That is roughly 35,000 people per square kilometer, which puts it among the most densely inhabited ground anywhere on Earth. Nuseirat holds 88,000. Khan Yunis camp, 95,000. Fighting inside that produces catastrophic civilian harm almost regardless of what anybody intends. Which leads to the second point, and it is the one that matters legally. Destruction on this scale is not evidence of genocidal intent, because we have seen it repeatedly in wars nobody classifies as genocide. Dresden and Hamburg were largely destroyed. Tokyo burned. Grozny was flattened twice. Mosul, Raqqa, and Aleppo were reduced to rubble by 3 different actors pursuing 3 different objectives. None of those is legally a genocide. Not because the destruction was smaller, but because destruction was never the test. The physical element was never the contested part of this argument. Everyone agrees it happened. The contested part is what it was for. Now the affirmative case, and it rests on a simple legal point. If a pattern of conduct admits an explanation other than intent to destroy the group as such, the inference fails. So consider conduct that has no place in a campaign of destruction. Evacuation warnings, millions of leaflets, recorded phone calls to individual buildings, and published maps dividing the territory into numbered blocks with advance notice of which would be struck. You can argue about whether these warnings were adequate, and there are serious criticisms. But a force whose organizing purpose was the destruction of a population does not systematically tell that population where the next strike will fall. Rwanda did the opposite. It broadcast to find people, not to move them out of the way. The direction of movement. Warned civilians in Gaza moved within the territory repeatedly, and the pattern of evacuation orders pushed populations away from areas of operation rather than concentrating them. Concentration is the operational signature of destruction, because destruction requires the group to be held in place. Srebrenica separated and held. Rwanda established roadblocks to stop movement, and aid entering the territory throughout, in disputed quantities and with contested adequacy, but entering, coordinated with international agencies, over a period of years. None of this proves benign intent. It does not have to. It only has to make an alternative explanation reasonable, and under the Bosnia standard that is enough to defeat the inference. Here is where most videos reaching this conclusion stop. They should not, because the case on the other side is stronger than they admit, and pretending otherwise is how an argument gets dismantled. So directly. In August 2025, the International Association of Genocide Scholars, the largest professional body in the field, passed a resolution stating that Israel's actions meet the legal definition. 86% of those voting supported it, though only around 120 of roughly 500 members actually voted in favor, and the process drew criticism from within the association itself. Several prominent Holocaust and genocide scholars have publicly changed their position, including academics who previously rejected the claim and who served in the Israeli military. The famine determination is real. Statements by individual Israeli ministers and officials have been genuinely extreme, and some appear to describe the population as a whole rather than a military target. These are not trivial. Any honest treatment has to hold them. But none of them establishes Dolus Specialis, and here is why. Scholarly consensus is not a legal finding, and the convention assigns that determination to courts, applying an evidentiary standard that a vote does not replicate. Famine and mass death establish catastrophic outcome, which is the physical element, and the physical element was never the contested part. And statements by individual officials, however repugnant, are evidence of intent only if they translate into the operational directives that shaped conduct. Under the Bosnia standard, the question is not whether terrible things were said. It is whether the pattern of conduct admits no other reasonable explanation. That is a different question, and on the evidence public today, it has not been answered in the affirmative. One more thing gets quoted constantly and understood almost never. South Africa brought a case to the International Court of Justice, and in January 2024, the court ordered provisional measures requiring Israel to prevent genocidal acts, punish incitement, and enable humanitarian access. Further measures followed. This is regularly reported as the court finding genocide, or finding it likely. It is neither. Provisional measures are emergency orders issued before any examination of the merits. The threshold is whether the rights claimed are plausible, meaning capable of being argued, not established or probable. The court is deciding whether to protect a claim while it is heard, not whether the claim is true. There is a useful comparison. In the same Bosnia case that produced the standard we have been using, the court issued provisional measures in 1993. It did not deliver its merits judgment until 2007. 14 years separated the emergency order from the finding, and when the finding came, it rejected most of what had been alleged while upholding one part of it. Provisional measures are the beginning of a legal process, not a verdict within it. The court has never ruled on whether genocide occurred in Gaza, and it will not for years. Written pleadings run into 2029 by the court's own schedule. So anyone citing the ICJ as having determined genocide is describing something the court has not done, and anyone citing the provisional measures as an acquittal is doing the same thing in reverse. Both readings misuse the same document. So here is the conclusion, stated precisely, because precision is the whole point. On the evidence publicly available, the pattern of conduct in Gaza admits explanations other than an intent to destroy the Palestinian people as such. Under the standard the International Court of Justice has itself applied, that is sufficient to defeat a finding of genocide, because the inference must be the only reasonable one, and it is not. Now what this does not say? It does not say the war has been conducted lawfully. Individual strikes may well constitute war crimes, and that is a separate question with a far lower evidentiary bar. It does not say the humanitarian catastrophe is exaggerated. Famine was confirmed. It does not say the death toll is acceptable, or that officials who said appalling things should face no consequence. And it does not say the question is closed. New evidence, particularly operational directives not currently public, could change the analysis entirely. A court may yet reach a different conclusion with material we have not seen. It says one thing only, that on what is known now, the highest bar in international law has not been cleared. That is a narrower claim than either side of this argument usually makes. It is also the only one the evidence actually supports, and a narrow claim you can defend is worth more than a broad one you cannot. If you disagree with this, the useful way to say so is specific. Name the evidence that establishes intent to destroy the group as such, and explain why it admits no other reasonable explanation. That is the actual test, and it is the argument worth having. The first video in this pair looked at where the numbers come from and who produced them. If you have not seen it, it is linked below, and it is the foundation this one is built on. These two videos are built to be watched together. The first establishes where the evidence comes from and how much weight it can carry. This one asks what the law does with that evidence. Neither works as well alone. Subscribe if you want more of this, and leave a comment if you think something here was wrong. Point at the specific claim and say why. Thanks for watching.